Hello, everyone, and thank you for attending today's webinar, Labor, Employment, and Employee Benefits Supreme Court Review. I'm Cliff Godner, co-chair of Thompson Coburn's Human Resources Practice Group, and I'm joined this morning by my partner, Rick Pautler, one of the country's leading ERISA litigators. Before we begin, we wanted to cover a few housekeeping items. So first, if you have any questions during this webcast, you can submit them through the Q&A widget located at the bottom of your screen. We'll try to answer those during the webcast, but if a fuller answer is needed or if we run out of time, we'll answer them later via email. Second, a copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you find useful. You can also find additional answers to some common technical issues located in the Help widget at the bottom of your screen. This webinar is accredited in California and Illinois for 1 hour of general CLE credit and in Missouri for 1.2 hours of general CLE credit. 1 hour of general CLE credit in Texas is pending. This webinar is also accredited for 1 hour of SHRM and HRCI credit. We award CLE based on attendance for the entire 60 minutes. From time to time, you will be required to click on a pop-up screen to reflect your continued engagement. Certificates will be sent out to qualified attendees within 48 hours of the conclusion of the webinar. We value your opinions and appreciate your participation in this course. And without further ado, I'll turn it over to my partner, Rick Pautler.
Thank you, Cliff. Good morning. Today I'm going to discuss 6 Supreme Court cases that directly impact the benefits community. Some of the cases have already been decided. Some have only recently been argued, and we are going to be waiting for decisions. And one is yet to be argued on November 10th. I have to admit that some of the issues we're going to discuss this morning are a bit dense, and there is not a whole lot of pizzazz in them. But I hope that you will stick with me because these cases may directly impact decisions you have to make or counsel that you have to give over the next few years. My purpose here is to put these cases on your radar so that if your CEO or your VP of HR stops by your office and asks, what's up with this case, or what's going on about this issue, you have something to say and can talk about them a little bit. The 6 cases are, there we go, Retirement Plans Committee of IBM versus Jander, Intel Corp Investment Policy Committee versus Sluma, Stoll versus U.S. Bank, Rutledge versus Pharmaceutical Care Management, Trump versus Pennsylvania. And then the last one is Texas versus California. The last one sounds as though we ought to be talking about a football game. But let's talk first about the Jander case. This case presents the naughty, and I'm saying K-N-O-T-T-Y, not naughty, N-A-U-G-H-T-Y, but the naughty issues that arise when an ERISA fiduciary, who is also a corporate office insider, is confronted with abiding by his ERISA fiduciary duties at the same time as he complies with federal securities laws. And you're forgiven if you're asking, what in the heck is he talking about? So let me try to bring this down to a little bit more Sally, Dick, and Jane. Let's assume for the moment that Sally is the CFO of company ABC and that she also sits on the investment committee of the ABC pension plan. When she acts as a member of that investment committee, she is an ERISA fiduciary, and she is subject to all of ERISA's rules and regulations. So let us assume that employees are able to buy stock in ABC through their 401k pension plan. And let's assume further that Sally learns that the company's promised COVID vaccine is causing numerous recipients of that vaccine to suffer serious side effects. And she rightly suspects that when this information is made public, ABC stock is going to plummet. But for now, this information is inside information, unknown to the public. It would, of course, violate federal securities insider trading laws if Sally were to use her inside information to go out and to sell all of her ABC stock in advance of this information being made public. But at the same time, there are hundreds of ABC employees who are buying this stock in their 401k plans in the belief that ABC is about to reap huge rewards for having the first COVID vaccine. Others in the plan, while not buying more stock, are continuing to hold on to their company stock in their 401 accounts in the hopes the stock will continue to go up as a result of the COVID vaccine. So let's assume that when the side effects are made public 2 weeks later, the stock rather predictably declines 30% in 2 days. All of the plan participants who either bought the company stock or who held on to it during that 2-week period sue Sally and all of her fellow committee members in a class action. And they assert that Sally and her fellow committee members had a fiduciary duty under ERISA to act on behalf of the plan participants and to tell them about the side effects that were going to negatively impact the company stock. And you know what Sally says? Sally says, I could not tell you because the federal insider trading laws prevented me from telling you. I will tell you that the courts have struggled mightily with this issue and what Sally is supposed to do in these circumstances over the past several years. In Fifth Third Bank Corp versus Dudenhofer, in 2014, the Supreme Court set out a 3-part test to apply when deciding whether to allow these types of lawsuits to proceed. One of those 3 tests was whether the plaintiffs had alleged that the fiduciaries like Sally could have, 1, taken an alternative course that would have complied with the securities laws, and 2, that a prudent fiduciary would not have viewed as more likely to harm the participants than to help them. You're excused if you have to go back and read part 2 of that test several times to figure out what the heck it is saying. But what the Supreme Court seems to require is that the plaintiff must allege that the defendants could have done X, whatever X was, and they could have done that in compliance with the federal security laws, and a prudent ERISA fiduciary would have believed that taking action X would not have harmed the plan participants more than it helped them. Put differently, the court in Dudenhofer held that a plaintiff's ability to identify a helpful action that the defendant could have taken, consistent with securities laws, is a necessary condition to an ERISA lawsuit. In this case, the Jander complaint, the plaintiffs alleged that the problems with IBM's business units were going to come out sooner or later, so that a prudent fiduciary would have concluded that keeping it secret for 2 weeks was going to do more harm than good, and that IBM could have made a disclosure of the business unit problems while still complying with federal securities laws. They couldn't have just disclosed it to the plan participants, but they could have made a public announcement sooner, and that would have prevented the participants from continuing to buy the stock to their detriment. The Second Circuit in New York said that that was enough, that the Jander plaintiffs had alleged enough to comply with the Supreme Court's requirement in Dudenhofer. Well, on January 14th of 2020, the Supreme Court remanded the case back to the Second Circuit. That means that the Supreme Court didn't decide the substantive issue. It instead sent it back to the appellate court and said, we want to hear what you think about some of these issues before we decide what we think about them. And we don't think that you adequately addressed these issues the first time, so we're going to give you a second bite at the apple. This decision was a per curiam decision. That means that all of the justices agreed with the decision, but no justice is identified as being the author of the decision. So you don't know who wrote the decision, but the idea is that all of the judges agreed with it. Basically, the court concluded that that IBM and the government had made arguments that the Second Circuit had failed to address, and the court wanted to know what the Second Circuit thought about those issues. The argument that they had not addressed was whether ERISA could impose upon fiduciaries a duty of disclosure that was even broader than what the federal securities laws require. In other words, even if federal securities laws did not require Sally to disclose the side effects, does ERISA impose upon her a duty to make that disclosure? Stated still differently, even if federal securities laws would have permitted Sally to wait 2 weeks to make the disclosure, did her ERISA fiduciary duty obligate her to make the disclosure immediately? After Dudenhofer was decided in 2014, these types of cases that we call stock drop cases, because they're all cases where the stock dropped precipitously after some information became public. These type of lawsuits had basically dried up because the plaintiff's counsel were not having any success and therefore were unwilling to take them. But if the Second Circuit holds that an ERISA fiduciary has a duty under ERISA to make these types of disclosures, even when federal securities laws do not require them, I think you're likely going to see an uptick in this type of litigation. And CFOs and other corporate officers who sit on plan investment committees will find themselves in some very difficult situations. And I have to tell you, I've been involved in a multitude of these lawsuits. And I think the CFOs always regret that they ended up on the plan investment committee, because they look back and say, man, we should have seen this coming, that I was going to be put in this position. How did I ever let myself get put here? The next case I want to talk about is the Intel case. And this case was decided February 26, 2020. It was a unanimous opinion written by Justice Alito. So I know we always see in the newspaper that the justices are greatly divided, but there are a lot of unanimous decisions which come out of the Supreme Court. So the issue here was, if a plan participant thinks that an ERISA fiduciary is guilty of a breach of fiduciary duty, he has a limited period of time within which to bring his lawsuit. He must bring that lawsuit within 6 years of the date of the last action which constituted the breach or the violation, or he must bring it within 3 years of the earliest date in which he had actual knowledge of the breach. And this lawsuit concerns, what does actual knowledge mean? In this case, after the 2008 stock crash, the investment committee took money out of the stock market and put it into alternative investments. These alternative investments required higher fees, and when the stock market rebounded, these alternative investments lagged behind in performance. The plaintiffs received multiple notices that the investment committee had moved money from stock investments to alternative investments. The defendant plan could even prove that this plaintiff had visited many times the website that disclosed in detail this switch in investments. But the plaintiff claimed that even though he had gone to the website, he had not read any of these disclosures. So the issue was whether he had actual knowledge within the meaning of the statute. I will tell you that I've won lawsuits on this issue in the past, where I could prove that we had sent confirmation slips, we had sent monthly statements, we had sent emails and other correspondence that detailed the change of investments, and that was enough to prove that the plaintiff had actual knowledge. But under this Supreme Court decision, it's unlikely that I would have won, because the Supreme Court concluded that there is a difference between a person, what a person actually knows, and what he ought to know, or what he might be presumed to know. Because Congress in the statute used the term actual knowledge, the Supreme Court held that if the plaintiff never read what he should have read, he still does not have actual knowledge. As a defense attorney, I will tell you that I worry that a properly coached plaintiff need only testify that he never read the summary plan description. He never read the annual reports. He never read the letters or the emails that were sent to him by the plan, and thus he did not have and does not have actual knowledge. I got to tell you that at the very end of the case, Justice Alito threw in one sentence that is kind of a bone to the to the defense counsel. And in that one sentence he wrote, "Today's opinion also does not preclude defendants from contending that evidence of willful blindness supports a finding of actual knowledge." So I ask you, if the plan participant received 5 communications explaining that the investment committee had made this decision to move plan assets to alternative investment, and he never read a single one of them, when does that become willful blindness? This sentence is the kind of sentence that makes money for litigators, because it's going to be much more difficult to dispose of these cases early on in the case. Before you can dispose of these cases now, it most likely will require you to take the deposition of the plaintiff to get him to admit that he had actual knowledge or that he had willfully blinded himself to this information. But again, not to be too cynical, a plaintiff who has been coached by his attorney most likely will testify he never read anything that told him about the actions that constituted the breach. And maybe there's really no need for cynicism on my part, because I will admit to you that I just agreed to a multi-page agreement that Apple had me push the button that said I agreed to before I could get the latest update on my phone. And I will admit to you, I never read a word of it. And I suspect most of you haven't either. It makes you wonder, in light of this lawsuit, when you send information out by email to your plan participants, should you require them to check a box at the bottom that says they read the information that appears on the site? Would that be enough to prove that they had the actual knowledge? The next case, our third case, is Thole versus U.S. Bank. This case was written June 1st, 2020 by only a 5-4 majority. The decision was written by Justice Kavanaugh, and the retirees here were in a defined benefit pension plan. In the past, they received all of their monthly benefit payments, but the investment committee had made an investment as a result of the 2008 recession that lost $1.1 billion. Allegedly, that was $748 million more than a properly managed plan would have lost. The plaintiffs claimed that the investment had been a breach of fiduciary duty. The allegation was that U.S. Bank had invested in its own mutual funds and had paid excessive fees to do so. The complaint also alleged that the investments allowed U.S. Bank to manipulate accounting rules and inflate the bank's stock price. The plan was underfunded when suit was filed, but after suit was filed, the company made a contribution of $311 million so as to make the plan fully funded. In fact, it was slightly overfunded. Well, the Eighth Circuit, which is the federal court of appeals that sits here in St. Louis, said that the plaintiffs did not have standing to bring the lawsuit because they had not suffered any harm. Now, the Solicitor General of the United States and the Department of Labor both argued that the Eighth Circuit was plainly incorrect. But at the end of the day, the Supreme Court, again by only a 5-4 majority, agreed with the Eighth Circuit. The Supreme Court held that because the plaintiffs were going to receive the same monthly benefit regardless if they won or lost, they could not bring this lawsuit. To have standing, the plaintiffs had to demonstrate that they had suffered an injury in fact that is concrete, particularized, and actual or imminent. Because the plaintiffs had received all of their past benefits, they had not suffered any injury that was concrete, particularized, or actual. And because the plan now was fully funded, there was no imminent risk of damage, no imminent risk that they would not receive future benefits. And therefore, they could not bring this lawsuit. Justice Sotomayor wrote a dissent that was joined by Justices Ginsburg, Breyer, and Kagan. The dissent said that the plan participants have an interest in the financial integrity of the plan, exactly like a private trust beneficiary, and that the participants had established that they had been harmed by alleging the $750 million loss. The dissent was adamant that the plan participants had at least an equitable interest in the plan assets that were lost, and thus they had sustained damage. The teaching lesson of this lawsuit for those of us who work on behalf of plans is that you may be able to dispose of a breach of fiduciary lawsuit simply by making contributions to the plan so as to assure that it is fully funded. The next lawsuit is Rutledge. It too comes from the Eighth Circuit that sits here in St. Louis. The issue in this case concerns whether states may pass laws that tell pharmacy benefit managers, I'm going to call those PBMs, how much they must pay pharmacies for drugs provided to ERISA plan participants. Or does ERISA preempt those laws? Here is what the problem was as perceived by the state of Arkansas. Sometimes PBMs reimburse their own mail-in pharmacies at a higher rate than other pharmacies that are not a part of their networks. And sometimes independent pharmacies, especially those in rural areas, pay more to obtain a drug from a wholesaler than the PBM is willing to reimburse it. In this case, the state of Arkansas argued that 16% of rural pharmacies had gone out of business in recent years. The Arkansas law required that the PBM pay at least as much as the wholesaler charged the pharmacy. 37 states have passed similar laws that attempt to control PBMs in some way. The Eighth Circuit held that ERISA preempted the Arkansas law. Preemption means that in this case that a state law cannot pass any law that impacts or affects an ERISA plan. ERISA was intended to create a uniform law, and that uniformity would be destroyed if California could pass one law that applied to a plan and Missouri pass a different law and Illinois and Texas still third and fourth laws. The Eighth Circuit said that the statute references ERISA plans and attempts to direct how they are to be administered, and that is enough for ERISA or preemption to apply. The Supreme Court heard oral argument on this case on October 6th, In the Supreme Court, Arkansas argued that its laws did not tell the plan or the plan sponsor or the plan administrator what to do. It only told the PBM what to do. And therefore, it did not interfere in any ERISA covered relationship. Thus, Arkansas argued ERISA preemption should not apply. I will tell you that the U.S. Solicitor General filed a brief that supported the position of Arkansas. It argued that the Arkansas law had only an incidental economic impact on ERISA plans and that such an incidental effect is permissible. I will tell you that ERISA preemption is frequently a hairy issue, and I'm not certain that you can reconcile all of the Supreme Court decisions on the topic. But I will also tell you that if the Supreme Court reverses the Eighth Circuit and holds that ERISA preemption does not apply, you should expect a flood of new state laws applying to PBMs, and that these laws are likely going to drive up insurance premiums because PBMs will most likely have to start paying more for drugs that come from certain pharmacies. Our fifth case is Trump versus Pennsylvania. It is a part of the long saga of the Little Sisters of the Poor, an order of nuns who has vigorously opposed being required to provide contraceptives to its employees. The ACA's birth control mandate requires most employers to provide their female employees with health insurance that includes access to certain forms of contraceptives. The Obama administration and the Little Sisters of the Poor went to the Supreme Court twice in their fight over whether the federal government could make an order of Catholic nuns provide contraceptives. But in 2017, the Trump administration issued new regulations under the ACA that extended an exemption from the mandate to allow private employers with religious or moral objections to opt out of providing coverage. This 2017 regulation meant that the Little Sisters of the Poor no longer were faced with the alternative of paying significant penalties or taking actions they believed violated their faith. Two states immediately challenged the 2017 regulation, arguing that it violated the ACA and that it also violated the procedure that federal law requires for administrative agencies to adopt such regulations. The district court held that the 2017 regulations were unenforceable, and the Third Circuit, which sits in Philadelphia, affirmed that decision and also said that the regulations were unenforceable, and it issued a nationwide injunction barring its enforcement. The Supreme Court heard oral argument in this case by telephone in May of 2020, and it decided the case on July 8th of 2020 in a 7-2 vote. Justice Thomas wrote the majority opinion. The two dissenting judges were Justices Ginsburg and Sotomayor. Justice Thomas noted that the ACA gave the Health Resources and Services Administration unbridled discretion to determine what constitutes preventative care and screening, but it also gave it equally unbridled discretion to create exemptions from those guidelines. Justice Thomas noted that the ACA itself does not expressly require health plans to cover birth control. So this requirement that was created by HRSA instead of the statute itself. Justice Thomas declined to decide whether the Religious Freedom Restoration Act required or authorized the challenged regulation. His ruling described above made the RFRA issue moot. But Justices Gorsuch and Alito made clear they believed that the Religious Freedom Restoration Act required this regulation. Justice Kagan, who was one of the 7 of the majority, suggested that the lower court should review whether the regulation was arbitrary and capricious or overbroad. I think when you read her decision, you know that she thinks it was arbitrary and capricious and overbroad. The book is hardly closed on this issue because if there is a Biden administration, it most likely will reverse the 2017 regulation, which will then take us back to where we were during the Obama administration, which will probably bring us back to the Supreme Court to address that religious freedom question. Okay, so the last case I want to talk about is Texas versus California. And this is a case that's going to be argued on November 10th, just about a week from now. In 2012, the Supreme Court held that the ACA's individual mandate that Congress would require all Americans to purchase health insurance was a penalty and therefore constitutional. You might recall that Justice Roberts said that the penalty was a tax, and Congress has the right to impose taxes so that the mandate was constitutional. But what happens if that tax disappears? Is the individual mandate still constitutional if there is no tax involved? Well, in 2017, Congress set the penalty at $0. The district court held that the mandate was unconstitutional in light of the 2017 law and that the entire ACA was invalidated. The Fifth Circuit held that the district court ruling that the mandate is unconstitutional was correct. Because the penalty is now $0, it will not result in any revenue to the federal government and therefore is no longer a tax. And because it is no longer a tax, the ACA was an unconstitutional exercise of congressional power. But the Fifth Circuit, in a 2-to-1 decision, sent the case back to the district court and said, what do you think Congress had in mind when it passed the 2017 law? And does this mean if that mandate is unconstitutional, does that mean that the entire ACA is unconstitutional or only parts of it are unconstitutional? Before the district court could complete that task, the Supreme Court agreed to hear the case. And the Supreme Court is likely going to address 3 issues, although you could break these issues down into 4 or more issues if you wanted. First, the issue is, do Texas and the individual plaintiffs have standing to bring this lawsuit to challenge the individual mandate? Second, did Congress's 2017 law render the individual mandate unconstitutional? If there's no longer any money coming to the government, does that mean it's no longer a tax? And if it is no longer a tax, does that mean that the underpinning of Justice Roberts' decision disappear? And the third question is, if the mandate is unconstitutional, what parts of the ACA survive, if any? I suspect we will not see the court's decision on this question until June of 2021. And finally, let me just throw in this little tidbit. If the Democrats were to win both houses and the presidency, it would seem likely to me that even if the Supreme Court holds that the 2017 law made the entirety of the ACA unconstitutional, the Democrats in control of both houses and the presidency could simply pass a new Obamacare, put the tax in, and we'd be right back where we were when the Supreme Court first upheld the constitutionality of Obamacare. So it seems as though the faster we go, the behinder we get in finding a decision on some of these difficult issues. And so now, Cliff, take over.
Thank you, Rick, and good morning, everybody. I'm going to talk about 2 employment cases now that the Supreme Court decided this past June, both of which I think are really fascinating examples of how different people can look at the same issue from completely different perspectives, and as a result of that, reach completely different conclusions. I'm also going to try to give you some predictions about what might be coming down the pike in the future based on what I see in those cases. So the first case we're going to talk about is Bostock versus Clayton County. which is, of course, the Supreme Court decision that decided that Title VII does indeed prohibit discrimination based on an employee's sexual orientation or gender identity. Those of you who have attended our sessions when we all got together live may remember 3 or 4 years ago I stood up and predicted that this would be the outcome that we would get from the Supreme Court, that this issue was coming and this is the way they decide it. But as the slide says, I can't take a single victory lap here. And there's a couple reasons why. The first one is, while I correctly predicted the result, I got the rationale wrong. I stood up and I talked about the gender stereotyping cases. The fact that Title VII liability had been found to exist if an employer got rid of a, let's just say, male employee because he didn't conform to male gender stereotypes, too effeminate, let's say, or a woman was too aggressive. And liability had been held in those cases. And I said, well, you know what? There's another gender stereotype out there. Men are attracted to women and women are attracted to men. And if you fire someone because they don't comply with that gender stereotype, sounds like a violation to me. Not at all what the Supreme Court decided, as we'll hear in a minute. The second one is, I was positive this was going to be a 5-4 decision. Even after the case was argued last year, I really thought, I read the transcript and I thought this is a 5-4, and Justice Roberts, who really has been in a lot of ways the swing vote on the Supreme Court since Justice Kennedy's retirement, thought he's going to be the guy who decides this thing. Wrong again. 6-3, and of all people, it's Justice Gorsuch, President Trump's first appointee, who writes the majority decision. So how does Justice Gorsuch get there? And he says a couple things really, and he says, first of all, this is an easy case. I can't imagine that he said it's an easy case. Something that people disagreed about, easy for him. And why is it easy? Because he says the text of the statute answers the question. And he looks at 3 words really in Title VII, that discrimination is prohibited because of, among other things, sex. And he says, all right, let's look at those 3 words. Sex means the biological distinction between men and women. So gender is what he assumes sex means in Title VII. Then he looks at because of, and he says because of means that but for the employee's sex, the result would have been different. That's what's illegal discrimination. So he says, look, the language of the statute's clear. If you change the employee's sex and that changes the result, then the statute's been violated. And he goes and he applies that standard to sexual orientation and gender identity. He says, okay, so an employer fires a man because he's married to a man. If they wouldn't have fired a woman because she's married to a man, there's liability. All he did is change the employee's sex. If that changes the employment decision, legal liability attaches. And you can do the same thing with gender identity. An employer fires an employee who identifies as female, but who was assigned male gender at birth. If you change the sex, would that have made a difference in the decision? So would the employer have fired an employee if she had been assigned female gender at birth? Answer to that is no. Then you've changed the employee's sex, it's changed the result, and so there's a Title VII violation. Easy for Justice Gorsuch. The other side is 2 dissents, one by Justice Alito and one by Justice Kavanaugh. And this is amazing, they say the text of the statute answers the question. Is exactly what Justice Gorsuch said, right? Read those 3 words and said that answers the question. So they say, look, Title VII says you can't discriminate because of sex. And so the question for us is, does an employer discriminate because of sex? If it fires someone because of that employee's sexual orientation or gender identity. And to the dissent, sex is not the same thing as sexual orientation or gender identity. Those are, to the dissents, distinct concepts. So they say, look, if you fire an employee because of their sexual orientation, you don't care about their gender. An employer that doesn't want to hire gay men or lesbians isn't worried about gender. They would hire both men and women. What they care about is sexual orientation. So two people all these justices, very, very smart people, looking at these same three words, because of sex, and reading them differently, and both telling us, all of them telling us, that those three words answer the question. So at the end of Justice Alito's dissent, he has this hypothetical, I think really kind of brings this distinction in the way they're looking at the statute home. So he talks about an employer that hypothetically has 4 employees and fires 2 of them. And they're listed here in this slide, and the 2 that are crossed out are the 2 that lose their jobs. Okay, so Justice Gorsuch analyzes that hypothetical, and he says, wait a minute, the top one, the man attracted to men. If I change the gender of the employee, so now it's a woman attracted to men, doesn't get fired. That's a Title VII violation. The woman attracted to women who lost her job, if you change her gender to male, she's now a man attracted to women, no discharge. So what Justice Gorsuch says is there's 2 Title VII violations here. Both of these people who got fired can sue. And the dissents look at that and say, wait a minute, men and women got treated the same. So nobody can sue. Just 2 different ways, 2 completely different ways to look at the same issue. Both of them, all 3 of these opinions, claiming to be textualists, and we've heard a lot about textualists. With, now Justice Barrett in her confirmation hearing talked about being a textualist. It's interesting to see that you can read because of sex in these different ways, completely different ways, really. And Justice Gorsuch looks at because of sex, and he says, that's my test. Change the sex, change the result. That's a legal violation. The dissent says because of sex is not the same thing as because of sexual orientation. In his dissent, Justice Kavanaugh actually concedes that Justice Gorsuch is right under what he calls the literal meaning of Title VII. So if you just read because of sex literally, he says, well, Gorsuch is right, but the problem is we shouldn't be looking at the literal meaning of the statute. We should be looking at the ordinary meaning. Ordinary meaning what a common person on the street would think it means. And because of sex, he says, most people don't think that's the same thing as because of sexual orientation. They consider those to be separate things. Really interesting to me how smart people come at this problem and see totally different sides of things. All right, I got 2 more predictions. I was so good at predictions the last time, I decided to charge ahead with 2 more of them. And these really aren't predictions about the outcome of cases. This is predictions about things we're going to see litigated going forward. These are issues that Justice Gorsuch discussed in his majority decision, but said, I'm not going to address them because they're not really presented here. And the first one goes like this. If the change the sex, change the result means there's a Title VII violation, can a male employee be fired right now for entering a woman's restroom or a locker room? Change the gender of the employee so now it's a woman entering a women's restroom or locker room? Justice Gorsuch, again, didn't decide that issue, said that's really interesting, but it's not the case here. But I suspect a case like that's going to be coming. Second one that he talked about is, what about people who say, well, wait a minute, I have a religious belief that causes me to want to discriminate or to desire to discriminate based on sexual orientation or gender identity. What if that's the rationale? And Justice Gorsuch says, well, you know what? That's not our case either. Neither one of these employers are arguing that in the Bostock case. But that's an interesting issue, and the Religious Freedom Restoration Act, RFRA, might have something to say about that, but we'll just deal with that later. I guarantee you that case is coming. Guarantee you that case is coming. And actually, what's kind of interesting is this topic of the way religion and how it impacts the anti-discrimination laws is one of the things that I think we're going to see a lot more of in the next few years. And we saw it in the second decision I want to talk about, the Our Lady of Guadalupe School versus Morrison Baru case. So I think all of us can appreciate there is somewhat of a tension between Title VII and its application to religious institutions. And I put on this slide what I think is the easy case. It's just an example, but, you know, it's one of the things that, at least when you think about it, it probably makes you go, that doesn't seem right. So can a Jewish synagogue refuse to hire a rabbi because that applicant is Lutheran? Okay, I think all of us have an instinct, well, of course the Jewish synagogue can hire a Jewish person to be the rabbi. So there is this tension between Title VII's religious discrimination prohibition, because certainly a secular company couldn't do that, and the application to religious institutions. So you can segue that then to religious-oriented schools. And Congress actually addressed that issue in Title VII and said that religiously affiliated schools could discriminate based on religion. But what about discrimination by religious institutions, religious schools, based on other protected characteristics like race and sex and national origin and all the other ones that we're familiar with as employment attorneys? So you really get into these First Amendment issues, because when you take it out of my hiring context and you take it out of the easy case, the refusing to hire a Catholic person to be a rabbi, what about this? That same rabbi, who's Jewish in this case, let's say, gets fired for poor performance. And he or she says, no, this was age discrimination. And you ask yourself, can the court get into that? Can the court decide whether the synagogue should have fired the rabbi? Remembering, of course, that the employment discrimination laws have reinstatement as one of the remedies. So in other words, if you say yes to that, then the synagogue could be forced to rehire this person and make them their rabbi. So you get into First Amendment issues. The free exercise clause that says the government isn't going to tell any of us how to practice our religion. And the establishment clause that says not only won't there be an official government church, but that the government won't get overly entangled with religion. And that issue kind of comes to a head in 2012 with regard to religious schools in the Hosanna Tabor case, where the Supreme Court created what's called the ministerial exception to Title VII. In that case, this is a Lutheran school, and the Lutheran school had teachers divided into two categories. They had lay teachers and what they referred to as called teachers. And to become a called teacher, you had to first want to do it. You had to take specific religious education classes, and when you completed it, you became, in the eyes of the school, a minister of the Lutheran Church. Certainly not the minister who leads services or something like that, but you became and got a title of minister. These teachers taught secular classes in addition to religion. They led their students in prayer, and the Supreme Court said, we're not going to let a teacher sue for disability discrimination when she was the minister, one of these called teachers, after she was 5. And they said, look, we're not going to have the government get into picking who is a minister for a church. Secular courts aren't going to get involved in those decisions. Can't under the First Amendment. So the issue comes back 8 years later, when there are two cases out of the Court of Appeals in San Francisco, the Ninth Circuit, involving Catholic elementary school teachers who aren't ministers, haven't had any formal religious education, teach secular classes and religion, lead their students in prayers, take them to Mass, and work under an employment contract that says that they're going to be evaluated, at least in part, on how they fulfilled the school's mission to develop and promote a Catholic school faith community. They got fired, one sued for age discrimination, one for disability discrimination, and this was not a close case in the Supreme Court, 7-2, saying no, those teachers cannot bring those lawsuits. The rationale, Justice Alito wrote the majority decision, was that it didn't matter whether you have a title of minister. It doesn't matter if you have formal religious education. What's important is that the teachers had a role in educating their students in the traditions and teachings of the Catholic Church. And he talked about, and I've kind of got this on the slide, that they both perform vital religious duties, that educating and forming students in the Catholic faith was at the core of the mission of the schools, and that, think about this, for elementary school teachers, their students spend the majority of the day with them. These were the members of the school staff who were entrusted most directly with the responsibility of educating their students in the faith. And as a result of that, he says, the church gets to pick, the school gets to pick their ministers without any interference from a secular court. And that's the holding here. When a school with a religious mission entrusts a teacher with the responsibility of educating and forming students in the faith, judicial intervention into disputes between the school and the teacher threatens the school's independence in a way the First Amendment doesn't allow. Justice Sotomayor, joined by the late Justice Ginsburg, is the dissenter. And she says, wait a minute, you realize what you're saying. You're saying that these schools can discriminate based on race and sex and national origin without any consequence? There's nothing that can be done? And so in her view, we should balance things by having a narrow ministerial exception. Sure, she says we don't want the government getting involved in picking who the rabbi is for a Jewish synagogue. Of course we're not going to allow that. But don't we have to balance things so that we try to root out unlawful discrimination? And she notes that neither one of the schools involved in this case actually required their teachers to be Catholic. They said they preferred Catholic teachers, but they didn't require it. And so in her view, the majority was actually allowing non-Catholics to be treated as Catholic ministers for purposes of the ministerial exception. Again, I think it's fascinating how smart people come at this problem and look at it really differently. And when you read Justice Alito's majority decision, what you see is he doesn't talk about the issues Justice Sotomayor is talking about. He doesn't look at, well, that allows bigoted decisions or something like that. He comes at it from the perspective of, we're not going to let the government get into the affairs of church-affiliated groups or schools. We're just not going to do that with regard to anyone who's involved in the teaching of religion or the forming of students in the faith. While the dissent says, wait a minute, rooting out illegal discrimination has to be balanced against that. Two sides really of the same coin. And I kind of hinted at this before. I think this is what's coming next, is how do you put these two cases together? Can you defend, if you're an employer, a claim of sexual orientation discrimination based on religious beliefs? There might be 8 votes now with Justice Barrett replacing Justice Ginsburg, and I really hesitate to predict where anybody's going to come out, whether any justice is going to come out on any of these cases. But it's either 7 or 8 votes for a broad ministerial exception right now. It'll be interesting to see. That case is coming, and it'll be interesting to see how it comes out. One other thing I want to talk about with regard to this case is when I read this, I really thought that was the end of lawsuits by religious school teachers against their schools, because the holding is so broad. When a school with a religious mission entrusts a teacher with the responsibility of educating and forming students in the faith, Justice Alito says judicial intervention into disputes between the school and the teacher violate the First Amendment. Then along comes a case called Demkovich versus St. Andrew the Apostle Parish. It's a Catholic school. Demkovich was hired to teach there. He's gay. He suffers from diabetes. He's obese. He has other medical problems, and he alleges that he was subjected to a hostile work environment by none other than a reverend of the church. Negative remarks about his weight, about his sexual orientation, about his medical condition, and he says, hey, this reverend, when I got married to my partner, asked me to resign, and when I refused, he fired me. So Demkovich admits he's a ministerial employee. He can't sue about his discharge. He doesn't. He brings a hostile work environment lawsuit. And the church school, for its part, it denies the harassment, but says, look, if they talked about the guy's sexual orientation, it was related to church teachings on the subject that the court really can't get involved in. And I have to acknowledge I was surprised by the Seventh Circuit's result here. They permitted the lawsuit to go forward. They said, well, all those previous cases, the Hosanna Tabor case, the Our Lady of Guadalupe case, look, those were about tangible employment actions. Hiring, firing, how much money somebody makes, promotions, demotions, those sorts of things. And those go to the way the church treats its ministerial employees. And we're not going to get involved in that. But courts should be able to protect employees of these institutions from the way their supervisors or coworkers treat them, which, after all, is what a hostile work environment case is. So we'll protect the church, but we're going to allow lawsuits that deal with what supervisors or coworkers do. There's a dissent. This case came out of the Seventh Circuit in Chicago. There's a dissent. So it's a 2-1 decision. And the dissent looks at it, not surprisingly, from the church's perspective, from the school's perspective. So wait a minute, if you're going to have a hostile work environment case, necessarily what that means is you're going to get into the work environment of our church, of our school, of the way we handle our employees, of the workplace that we've set up. That's the only way you're going to be able to figure out whether there was severe or pervasive harassment, which is, of course, the standard. But remember, we've talked, the First Amendment doesn't permit the government to regulate the way a church or a church-affiliated group operates. And so, really, can they look at the work environment? And in this particular case, the dissent says, hey, this is going to require us to examine the reverend's views on same-sex relationships, which will necessarily examine, then, the church's views on that subject, which is something the courts, after all, aren't supposed to get involved in. So, is that right? I mean, we've looked at this holding a couple times. What they said is that judicial intervention, this is Justice Alito, judicial intervention into disputes between the school and the teacher threatens the school's independence. So, where is there a distinction there between hostile work environment claims and tangible employment action claims? I don't see it there. On the other hand, think about what if you disagree with the Seventh Circuit, what you'd be allowing. It would mean that a Catholic school teacher could be sexually harassed by her boss, and there would be nothing that could be done about it in terms of Title VII liability. And is that really where we want to go? So, a fascinating issue. I don't know where this is going to come out. I can just tell you that right now there's a petition for rehearing in banc for the full Seventh Circuit to decide this case. It's been pending for several months now. And there is a Ninth Circuit case also that allows people to sue for hostile work environment claims if they're ministerial employees. So if the Seventh Circuit comes out the other way, you'll have a circuit split, and you'll have an increased likelihood, I think, of the Supreme Court taking the case. This whole issue of the way religion and Title VII, how they work together is something that I really think the Supreme Court's going to be digging into shortly. And so we will see in the future what happens with this case. We've used up our time. I have not looked at questions and answers, but I know we've used up the time that we have. For any of you, Rick, I don't know if you saw anything there that you wanted to address.
Cliff, there are 3 questions that have been directed to me that I think I can respond to rather quickly. One question was whether the actual knowledge standard that Justice Alito announced in that case and what it means, would that same standard apply if it had been a health plan rather than it being a pension plan? And the answer to that would be yes. The actual knowledge statute applies to all ERISA plans, whether they are welfare plans or pension plans. Another question says, well, the tax being $0 for the ACA, does it make a difference the fact that Congress reduced the tax to 0 as opposed to simply eliminating completely that provision that allowed for a tax? And the short answer is I don't know. I do know that the government's position is that when you have a tax that brings in $0, it's not really a tax at all. And so I think that the other side may make this argument that, hey, they didn't get rid of the tax provision. They simply reduced it to 0. But at the end of the day, I'm not certain if that's going to make any difference in the Supreme Court analysis. And the final question was, the odds of the Democrats having all 3 branches is looking rather slim as we sit here today. What happens to the ACA then if the Supreme Court rules that it's unconstitutional? And the answer is we go back to our very effective political system and get something through Congress that the president signs. And who knows what, if anything, that might look like. Okay, Cliff.
All right, so thank you, everyone, for attending. We really appreciate it. This is the last in our weekly series of labor and employment webinars that we're doing. We'd ask you to please complete and submit the survey that will display at the conclusion of this webinar. And again, thanks, everyone, for attending.